Hello and welcome to The Big Picture. The much criticized and much feared Section 66A of the Information Technology Act, inserted in 2008 during the UPA government, has been quashed by the Supreme Court. This is seen as a triumph of the constitutionally safeguarded freedom of speech and expression. The fact that this section had been used, misused and abused by various governments across the country, and especially to protect politicians, had made it look draconian. In fact, the Apex Court described the section as indeed draconian while quashing it. The fact that such a provision was passed in the Parliament with hardly any discussion is also a matter of concern. That the present government also went ahead supporting the provision in the Supreme Court is also another matter of concern. Now that the provision has been quashed, some questions need an answer, including what will happen to those who are being prosecuted under this section. How soon can they expect relief? And how will future cases of similar nature, which were being prosecuted under 66A, be handled? And if the internet space needs more safeguards? We will discuss all this today with Bhat, Senior Advocate in the Supreme Court, Vinit Goenka, Co-Convenor BJP National IT Cell, Rajesh Chharia, President Internet Service Providers Association, Satya Prakash, Legal Editor Hindustan Times, and on the phone line is Rajeev Chandrasekhar, MP in the Sabha, and also one of the petitioners before the Supreme Court in the case. Welcome to all of you. Mr. Bhat, I would like to come to you first. First, let us get this thing out of the way. Now that this section has been quashed, what does it mean? Does it mean that this section automatically, is erased from the Information Technology Act, or is there any procedure parliamentary procedure which is necessary for this?
It is dead right from the beginning. It is as if it has not been enacted at all. So for all purposes, this section was never there.
So for all purposes, this section was never there, okay.
So there is never there. Nobody can be prosecuted for a violation of that particular section.
In future, but what happens to people who are already being prosecuted? What happens to all those cases?
Nothing survives. Nothing survives. As if this section was not born at all. It was.
Mr. Bhat,
so there is no question of anybody being prosecuted.
No, people who are already being prosecuted, cases which have been filed against them, cases are pending in courts.
Everything will have to be dropped.
So but the people who are being prosecuted will have to file some kind of an application before the court, or does it automatically get erased?
You see, it is a matter of formality, but no court has power to proceed with the matter at all. So there is no question. Even if they pass some punishment, it will be invalid.
Okay. Now that has been clear. Mr. Rajeev Chandrasekhar, 2-3 matters of concerns here which I also raised in my introduction. You have been an MP for quite some time and you have been fighting against this provision for quite some time also. But what came in the way of the government, withdrawing this section?
No, I am not. This is only for the various ministers to answer. This issue has been an issue. As you know, this bill was passed in 2008 without any debate. I had stepped out of Parliament for a glass of water, and by the time I came back, the bill had been passed without any debate. So this bill has never had scrutiny, has never been questioned, never been challenged. And this fact was known to successive ministers and the government of the UPA starting from 2008.
Right.
This issue was raised in Parliament on a number of occasions. And as a matter of fact, in 2013 May, the then telecom minister gave an assurance on the floor of the House that the act would be reviewed. The Section 66A would be reviewed. And nothing was done. So, it was left with no option but to approach the Supreme Court, and it is the Supreme Court that is now increasingly doing what is right as opposed to government and parliament. It is a bit of a tragedy, but that is the reality of what is happening now in India.
So, so generally there was a, and one more thing, Mr. Rajeev Chandrasekhar, is that, the previous government brought in this law, there was no discussion. The present government continued to support this law even in the Supreme Court. Why do you think it happened? You are, though you're an independent MP, you're close to the government, have you been having any dialogue with the government, and why did the government go ahead and support this in the Supreme Court?
No, when the government took office in 2014, there was a petition that was filed by the ASG that was very similar to the petition filed by the previous government.
Right.
And I had a discussion with the telecom minister at that stage, Mr. Ravi Shankar Prasad, and it was his view that it is for the court to decide. This matter was sub judice. It is a constitutional matter. There was little room, this is his interpretation, there was little room for the government to interfere at that stage, and it is really for the court to pronounce the constitutionality of the act. So I think that was I am not part of the government and I have briefed for the government, but this is the understanding I had, that the issue which was in front of a bench needed to be resolved by the Supreme Court to once and for all decide the constitutionality of the section, since the matter was already in front of us.
Okay. I think Mr. Bhat, would you like to come in now?
A moment.
Yes.
Yes. You see, the number one, you ask the question, why not withdrawal? No government has the power to withdraw any parliamentary provision. It has to be amended. The act will have to be amended like any other act. So the process of amendment, you know what it is.
So, but
and
the
then
amendment,
as far as the defending in the court is concerned,
yes,
it is normally no government will go and say that, look, I don't defend it, because then they will leave it to the court in an adversarial system, because they will have to put forward a view, because then it is normally not done that, look, I'm sorry, I withdraw this provision. I mean, I don't oppose this petition. This type of action can be taken if the whole government proposes it, but it has not been done in this case.
Absolutely, it was not done in this case.
And I don't find anything unusual in that at all.
Okay, Mr. Vinit Goenka, there must have been a lot of discussion within the party about this particular section. Yeah. And when there was an opportunity, as Mr. Bhat says, there was an opportunity. If the government wanted, they could have gone to the court and said that we are not challenging these petitions which have been done. And now what your IT minister is saying is that we have always been against it. Then why, as a government, they did not take action?
We'll have to go to little facts of the details. See, it was proposed by the then DMK Minister Dayanidhi Maran in the UPA government. And if you see, our leader of opposition, then leader of opposition, Arun Jaitley, had spoken against this very nicely. And even Narendra Modi ji, when he was the Prime Minister candidate in 2012, had actually blackened his display in the Twitter and said that this is an reckoning. Against this, he is trying to display his displeasure. Now, we were always against this. I personally had agitations. I had my own views which I had forwarded. The party was always vocal about the Doctrine Act, and we were against this. But as my co-panelist said, once it is in the court, then the government can only do is to wait for the court judgment. But what we did is, very aggressively, we supported the petitioners who were there. We did not speak much about this. We also viewed that this cannot be read in an interpretation whereby it is seen as to be a curbing of power of speech. So the right of speech was not to be curbed. What we did is gently convey to the court that what is our opinion. So I think what Ravi Shankar ji said is absolutely what he maintained, saying last for 3 years, that we are against this thing, and we were very happy yesterday when this came up.
Satya Prakash, was that what happened in the court?
No, to say that the government was against the this provision. And the India government, that may not be correct. What they did was they slightly changed their stand towards the end when they saw that
towards the end,
and then they
said.
But
there was an affidavit saying that please continue with section 66A. We will not misuse it. We are assuring that we will not misuse it.
It has been recorded in the judgment where the Supreme Court said that the government has said that we assure you that it will not be misused. And the court said that we cannot go by assurance of the government. This governments come and go. This government is there. Maybe they will faithfully obey the words given to the Supreme Court. But what about the next government? But the stand of the government changing, that the fact that they said it should be retained, and we will not misuse it, that is what the Supreme Court has taken. I am glad that the Supreme Court did not buy the assurance given by the government. Why? Because if a law appears to be prima facie, appears to be unconstitutional, the court would not go by the words given by the executive. They will examine it and they have rightly thrown it in the dustbin. This law, as Mr. Chandrasekhar has pointed out, was passed in a hurry.
Yes.
I suppose it was December 2008.
Right.
One particular day it was passed by one house, the very next day the other house, and the law was passed without any discussion or debate. This is a sad commentary on the process of lawmaking in India.
And immediately, the misuse began.
And misuse, not immediately, because it was notified in sometime in around middle of 2009.
That's right, after that.
But the fact that this kind of law can be enacted, despite having various checks and balances, like you have a parliament standing committee system, you have both the houses, one house, they are supposed to examine it and discuss it.
Surprisingly, standing committee did not have any problem with this law.
No, because
it did not make any comments that,
One problem is that law, technology is changing very fast, and everybody is not like Mr. Chandrasekhar, who is well versed.
Understands
So the implications of change in technology and how laws should be changed to tackle that problems posed by change in technology, that I'm sorry, many of our lawmakers may not be aware, and that they need to be aware about. Why? Because the implications of this kind of gap between technology and law.
And the changing technology.
Yes, changing technology and law, because technology is changing very fast and law needs to catch up with that. If you don't, then there is a huge gap leading to this kind of problem.
Mr. Rajeev Chandrasekhar, I'll come to you, Vinit. Mr. Rajeev Chandrasekhar, was that the problem? As Satya Prakash rightly points out, there is to a certain extent lack of understanding of the changing technology among the lawmakers. Would you agree with that? Was that one of the reasons why the standing committee really did not see any of these problems cropping up with this section?
No, you see, the standing committee is not parliament. Standing committee is a microcosm of the parliament, and it makes its recommendations. Every law has to be tested by parliament, a parliamentary debate. And I don't agree that there are no parliamentarians who don't understand technology, etc. Because if you remember, I made the point that in 2013 May there was a full debate in parliament about Section 66A, where MPs from across party lines, many MPs, including my very close friend P. Rajeev from the CPM, participated in a debate, and we had the government on the back foot on this issue.
Right.
So the issue was that this bill did not, unfortunately and regrettably, did not have the opportunity to be debated in Parliament. Every bill that is debated in Parliament comes after the debate, becomes a better bill. This bill suffered from that infirmity, that it never was given an opportunity to be debated and tested by Parliament and including the media.
Absolutely.
Now, if I may. Yeah, and there's one other point that I just want to make a point.
Yes.
Is that unfortunately the DNA of this bill, the origins of this bill was about controlling the internet and regulating the internet.
Right.
In my opinion, whatever the government does in the future, moves forward, has to have two objectives. One is maintaining free speech and maintaining a safe internet. These are not mutually exclusive objectives. These can be compatible, and these can be twin objectives of any new policy or any new law that the government brings or any new amendments that the government brings.
Okay. Yes, Mr. Bhat, quickly. Before I go to, I have to go to Mr. Chharia there.
You see, the sting is not really in 66A. 66A merely says that it is an offence to do X, Y, Z.
Yes.
But Section 80, which empowers a police officer, like an inspector now, formerly it was Deputy Superintendent of Police and above the rank. Now an inspector and any officer authorized by the state or the center can go and arrest anybody from any public place. That is the sting really. 66A merely says that doing so and so will be an offence punishable with 3 years.
Right.
That's a different thing.
No, but what now?
What has happened in all these cases is somebody going and arresting because Azam Khan's buffalo criticized, therefore arrest him.
Okay.
That is the sort of problem.
I'll come. But Mr. Bhat, one clarification. So what happens to Section 80 now? Does Section 80 continue? Yes. What will be the impact?
Section 80. No, Section 80 continues because there are various other offences still in the statute.
And but the same problem...
Because there are a large number of other offences.
But the same problem continues that an inspector can go
all of them are not dealing with Article 19(1)(a).
Okay. Yes, Vinit.
See, it will be incorrect that BJP never had a views before this government. When the NDA government was there, Jaitley spoke furiously.
We agree with all that. But the crucial thing is what he said, that you went to the court and said that please continue this section. We will ensure that it will not be misused.
No, it is an half truth. You will have to speak.
What is the full truth?
Here, the government has said that there will be restrictions been put in, there will be a lot of responsibility been put in, and it will not be used. See, no other government,
but the earlier government obviously Supreme Court did not buy that argument. Let me get Mr. Chharia in on that. Mr. Rajesh Chharia, now that this section has been quashed, what is it as far as the internet service providers are concerned? There are also other issues as far as Section 69A and 79(3) are concerned. Are these two, which the Supreme Court has upheld and said that since there are enough safeguards, these two sections will continue. What is now, have the concerns of the service providers been addressed now?
No, service providers' concerns were not with the 66A. The 66A exclusively was for the users only.
Right.
We are the licensee of licensor, and whatsoever our licensor advises, we act according to that.
Right.
So we don't have any challenge about this section, and I'm not going into the litigity of the law, but I really appreciate the version of Mr. Rajeev Chandrasekhar that this law was passed in such a hurry that the industry doesn't get time to understand and to recommend anything to the government. This was so hurry that all of the sudden we found that the IT Act has been passed, and after a few days or few months, this was being legalized. So what we can say from the technology side that if the industry should have got the opportunity from then government about this law, before making this law, we should have given our suggestion in the interest of government, in the interest of user, as well as in the interest of industry.
Okay. No, but what about, one second, what about Section 69A and 79(3)? Now, Section 69A is about blocking and 79(3) is about takedown notices. These two, the providers will have to deal with it. There are criticisms even now and concerns that, some of these sites which function from outside the country, they don't react and respond to situations. What do you have to say about that?
This is the problematic condition that we are getting numerous orders from the Honorable Court. We are getting numerous advices from our licensor of blocking of the website, while on every meeting we have suggested that the subjective content should be blocked at the origin. If the content is coming from the overseas, it should be blocked at the cable landing station or the international gateway. Or if the content is originating from India, we should directly talk to those content provider or that data center to immediately remove that content. Otherwise, what happened when the moment you continue with the messages all over the ISP or all over the industry, you find that the people who are not interested in seeing those content wants to see because that has been advised to block. So my concern to the industry is that we should be very careful, and our government should ensure that the content or the disputed content should be blocked. Similarly, like what happened last few days back when this India's Daughter movie or documentary was on the YouTube, India's Daughter, all the list has come to the service provider for blocking of the website through the association. So this is the concern, because we should have taken the action at the initial point rather than going at the last point.
Okay. Yes, Vinit, you wanted to respond quickly.
See,
One of my question to Mr. Bhat is that the people who have suffered due to the 66A, what relief they are going to do, because they have gone through a very insultive time.
Mr. Bhat, please, Vinit will react first. I'll come to you, Mr. Bhat.
I would like to stress upon the role of the then government, because if we don't do that, it will not be doing the justice to the entire discussion. So we have seen Congress implementing emergency in 1975, then there will be license Raj or censorship.
Let's not politicize this issue.
I'm not politicizing, but I'm trying to bring it. So it is that mindset of denial which the UPA had that time. And with that mindset of curbing the freedom of speech, the mindset of not allowing common man to speak what they want to do, mindset of not allowing the press to speak was the mindset. So let me just complete. Let's take one more minute. Here, that mindset was playing behind the law.
Was that the same mindset which allowed the government now to go and give that kind of affidavit?
No, the moment
the present government also took the same stand.
We have not gone to the court saying that we want to have these provisions as it is. We said
when the court asked you, you provided affidavit, Satya Prakash. Can you clarify on that?
But 2 points. One, that they said we want to retain this provision, we will not misuse. But they also said we'll review the law. But that is neither here nor there.
I'll take this. Yes. This statement was very clear. If you see Modi ji's statement, Ravi Shankar Prasad's statement, or
statement and the action in the court, there was a problem with that. Anyway, Mr. Bhat, let me get Mr. Bhat. Yes.
Yeah. For the suffering which one has undergone during the existence of a law, there is no remedy. You can't claim damages against anybody, because this is a legislative action. It is valid until it is struck down.
Right.
If an executive were to act without the authority of law, you would have had some remedy in terms of damages.
Okay.
But not in the case of an legislative act.
Okay. Okay, sir. Mr. Rajeev Chandrasekhar, the question now is, if now we have to move forward. One of the two things, I asked this about section 69A and 79(3). You don't have any concerns about these two sections anymore?
No, look, no. I think we've got to understand that the law has a certain architecture, and the architecture places a certain responsibility on the intermediary. Now, that is the way the law has been framed. Now, like I said, this law has not been discussed, nor has it been debated. I would argue that there is a need for a new law wherein the role of the intermediary and the role of the government vis-a-vis directions to the intermediary needs a review, which is the section that relates to 79.
Right.
There is also a need for a debate on Section 80, which is empowering, which is the section that deals with who is empowered and what is the basis of that empowerment to pursue criminalized offences under this Act.
Okay.
So I would argue, and I have been arguing, that there is a need for a new law to replace what is already a 7-year-old law, which has been proved to be full of flaws.
So you think that the Information Technology Act 2000 needs to be completely rehauled? Is that what you're trying to say?
This is my argument, that we are now 8 years into the future. The government of India now has Digital India as its key priority. The government's role needs to be that of an enabler, not of a controller and a big brother in the cyberspace.
Okay.
So there is a law that needs to come in that defines the role of government, that defines the role of an intermediary, and that allows free expression, innovation, and creativity on the net.
Okay. Yes, Mr. Bhat?
No. I said, look, it is always people like Mr. Chandrasekhar who have got the experience. They must bring in a new bill.
That's exactly the point he has made, Mr. Bhat. Mr. Chandrasekhar has made that point that the new law maybe or a complete rehauling of the existing law needs to take place. Mr. Chharia, is that what would also be best for as far as the service providers are concerned?
Definitely, service provider recommends and suggests that whenever the new laws is coming, it should be in consultative process and as per the new technology going on. because a lot of flaws are there into the old law, and the technology has developed a lot. So we should be pacing according to the technology. We should not be going in the past and referring to the old policy or referring to the old technology.
Okay, Vinit, has there been any kind of discussions or consultations within the party, within your IT cell, with the government, for some kind of a rehauling of the law, what Mr. Chandrasekhar suggests?
See, there have been debate going on and discussion going on from 2008 itself, not only now. And this has been going on regular basis because we all were against this kind of...
No, now, in the light of the Supreme Court judgment.
Yeah, I'll tell you. If I don't make this precedent, then it will not hold up. So we have been against this, and there are enough provisions in IPC itself. You see 116 and other, which takes care of all these kind of defamations and seditions and whatever can be the hatred which has been spread. Now there is no need of new law. But same like one of the co-panelists said, the change of technology and the current times, we may have to amend the laws. So probably we don't have to come out with another act altogether. Maybe there is slight amendments which can be done. There are discussion going on, and after this experience, I think any government would always like to have a debate on this discussion before it goes on to the floor of the House. So this is going on. I would like to just bring back the discussion. We are trying to miss one point, the mindset and the desire of the person in the government. See, if we don't debate that, then the entire discussion will not go.
No, this has been much debated. We have it has happened across the country. Different governments have misused it.
There has been much debate and our stand that there should be free speech. We are the sufferers. We have suffered in 1975.
This has happened.
And Congress which did it. And which point we don't do it.
I think, Satya Prakash, this has been, regardless of which party is ruling where, this particular section has been misused quite extensively.
But one particular point, what Mr. Chandrasekhar said, that it should be debated. But before it is debated, what is important is drafting. The way the law was drafted, and Supreme Court has found fault with the drafting itself. After the drafting, it goes for vetting in the legal department. And Law Ministry is supposed to vet the law and to see whether the provisions are in conformity with constitutional provisions.
Right.
If they are not, then there is in all likelihood...
So there was a lacuna there also.
Lacuna there also because most of the provisions, there were 3 provisions under Section 66A. They all had... It was not properly drafted, it was completely vague, and the terms and expressions used in this provision...
Absolutely, the definitions, there were no definitions and things like that.
I like
very quickly.
Yeah, I'm coming back to the intentions part. See, let me just come out with the cases. It was NCP and Congress in 2011...
We don't have time for that.
No, but if
I'm sorry, we don't have time for that. Mr. Rajeev Chandrasekhar, finally... Are you there? Okay, I think we have lost him. Mr. Bhat, very quickly, a new law or... amending the existing law.
See, Girish, in a matter like this, no draftsman can frame any law. Because it is only the technologists, because first you have to understand what is the technology, and then comes the law. What has happened here is, somebody simply knowing IPC and CRPC cannot bring about information technology law.
Okay, sir. On that note, we need to end. This is a debate which needs to continue.
Thank you very much, sir,
this needs
for
to
speaking.
This needs to continue. This debate needs to continue because if there is going to be a new law, as Rajeev Chandrasekhar suggests, or as Vinit suggests that amending the law, hopefully the new law or amendments to the law will be more responsible than what it was earlier. Thanks to all my guests. Please keep watching. We'll come back with another issue, the big picture, same time tomorrow.